Hi, I'm Owen Jones at Doyle Clayton. I'm an associate here and head of business immigration services. And today I'm going to talk about the business immigration implications of internships and work experience placements. So, what are the most appropriate routes for interns when bringing them into the UK? Well, of course, there's no issue for nationals of the EEA countries, that's the European Economic Area. They automatically have the right to work in the UK and they can come in and work as interns. Those foreign nationals who are already in the UK as students are also able, in most cases, to work in the UK on a limited basis. Now, students can traditionally work in the UK for up to 20 hours a week during term time and for full time outside of term time. So, traditionally for internships taking place over the summer months, most students will have the ability to take on that internship. But of course, it's important to check the exact terms of the students' leave to remain rights, because some students do not have the ability to work in the UK, and that is nowadays usually for those students studying below degree level. So again, ask to see the passports, check the exact endorsements in those passports, and if there are any questions, then do take legal advice on them. Where it's clear that you have an individual who you'd like to bring in for a period of internship who does not have the right to work in the UK, there are various options. It used to be that you could apply for what was known as a TWES work permit, training and work experience. But that went by the wayside back in 2008 when the then existing 80 immigration routes were reduced into 5 main tiers. So it's the 5 main tiers we've got to look for to find a solution. The one tier that is used and is suggested for use by the UK Border Agency is within Tier 5, temporary work, and that is Tier 5, Government Authorised Exchange. Now, the Government Authorised Exchange programme envisages there being an overarching sponsor who issues a certificate of sponsorship to bring in the individual to the UK. The problem with this is that individual employers, on the most part, cannot be that overarching sponsor. So it's necessary to find an overarching sponsor who will assist you in bringing in the overseas national. Now, that might be easier said than done. Unfortunately, for many industries within the city and financial services, it's difficult to find a ready-made overarching sponsor. What is the solution? Well, one organisation that might be of help is BUNAC, that's the British Universities North America Club. Now, they're willing to work with any industry throughout the UK, and in the right circumstances will issue a certificate to allow you to bring in an overseas national for a period of internship. So, aside from Tier 5 Government Authorised Exchange, what are the other solutions? Well, one solution is to use Tier 5 Youth Mobility. Nationals of certain countries can come into the UK for up to 2 years and work in the UK. So, if you have a national from Australia, Canada, Japan, New Zealand and Monaco, there's reciprocal exchange schemes in place that allows them to come into the UK. So it might be possible to get them into that category to allow them to undertake the internship. Otherwise, it's more lateral thinking. It might be possible in some circumstances to use Tier 2 of the points-based system to bring in an individual for a period of internship. Finally, in some cases, Tier 5 post-study work might be of use, where you have an individual who has studied and obtained a degree level qualification from a UK institution. It is possible to switch them into post-study work to allow them to continue to work for any organisation in the UK. So, what are the consequences of getting it wrong? Well, an organisation risks committing an illegal working offence, and that's both the civil offence of employing somebody without permission to work in the UK, which brings with it a fine of up to £10,000 per illegal worker, together with the criminal offence of knowingly employing somebody without permission to work in the UK. That's a more serious offence and indeed brings with it unlimited fines and prison sentences of up to 2 years. So, you can see it's a serious business, but it's not just the fines that organisations need to be worried about. It's also the reputation risk for one. The UKBA does name and shame those organisations which fall foul of illegal working laws. Also, for those organisations that are licensed as sponsors under Tier 2 of the points-based system, well, they risk losing that sponsorship licence. That has serious consequences. Not only would it lead to the likely repatriation of your existing migrant workers, but it would also lead to difficulties in bringing in anybody else in the future. For the individuals concerned, they might also risk a re-entry ban to the UK of up to 10 years. Thank you for listening today. If you'd like more information, please do contact me on the number below.